If this is a drug case, which is it meth? Is it cocaine? Is it heroin? What type of drug that they're saying you possess? And is it an illegal substance, something that you're not allowed to have? Cocaine, marijuana, meth, heroin, right? They'll look at that and they'll see if there's a report in there from a chemist saying, we tested these drugs and it's heroin, meth, cocaine, or whatever it may be. And then they'll look at the chemist so that chemists can say, what's the weight of this drug? So you're charged with manufacturing delivery, penalty group 1, 4 to 200 grams. So he wants to know, is the chemist saying the weight of it is between 4 and 200 grams?
And I'm an immigrant. And sorry.
No problem.
And I own a company named Trafficking.
Mm-hmm.
And I don't know nothing about the judicial system, man. Honestly.
All right, so let me explain something about the judicial system, okay? And I understand that sometimes people find themselves in situations, they're young, maybe they're doing dumb things. But let me tell you how the legal system works in general, and then I'll tell you how it works in the 187 District Court, okay? So this is what ends up happening. A person gets arrested by the police. Maybe they get arrested, maybe they don't get arrested. Maybe you're just out and about and the police have investigated an offense, but maybe you're not at the scene, right?
Yeah.
So you may end up having a warrant and you don't even know you have a warrant. You're just out and about enjoying your life and then you get arrested. Now, sometimes you get arrested at the scene. Now, when you're arrested, either if it's at the scene or not at the scene, what ends up happening is there's a process where you get booked. And a magistrate will read you your rights, which will tell you about the right to remain silent. We can have an attorney appointed for you. If you can't afford one, if you can afford one, you can hire one. And they'll go through this process where they take information from you to see if you qualify for a court-appointed attorney. And they'll tell you can talk to people if you want to talk to the people. And by people, I mean police officers, prosecutors from the state. But if you talk to them, anything that you say may be used against you in a further proceeding. If you have an interview with them, you can stop that interview at any time. So once the police officers do their investigation, if they believe a crime has been committed, you get arrested, a bond gets set, and then that case is sent to the DA's office. They do their discovery on it. Then ultimately you end up in some court. The court you end up in is sort of random. There's some exceptions, like if there's a co-defendant in the court or something, but otherwise it's just a random court you end up in. Then you get appointed an attorney. That attorney looks at the information that the state has. In your case, you're charged with a drug case. So what they look at is they'll look at the police reports. When they look at the police reports, they will look at certain things to make a determination. Hey, is this a stop in a vehicle? If it's a stop in the vehicle, then they want to know, was this a good stop? Why did the police pull you over? If it wasn't a situation as that, if police had a search warrant for your arrest, a search warrant for property or something for your home, then what will end up happening is then that attorney will look at that search warrant and see if that search warrant has probable cause in it. Or if there's a arrest warrant, they'll look and see if the arrest warrant is appropriate. So once the attorney does all of that and says, you know what, this stop appears to be great, or this search warrant or this arrest warrant is a good search or arrest warrant, then they start looking at the facts of the case. And they look at the facts of the case by reviewing police reports or whatever the state may have. If this is a drug case, which is it meth? Is it cocaine? Is it heroin? What type of drug that they're saying you possess? And is it an illegal substance, something that you're not allowed to have? Cocaine, marijuana, meth, heroin, right? They'll look at that and they'll see if there's a report in there from a chemist saying, we tested these drugs and it's heroin, meth, cocaine, or whatever it may be. And then they'll look at the chemist so that chemists can say, what's the weight of this drug? So you're charged with manufacturing delivery, penalty group 1, 4 to 200 grams. So he wants to know, is the chemist saying the weight of it is between 4 and 200 grams? If it is, and the chemist is saying, hey, yeah, then the next thing he will do is, in this court, I require that the defense get an offer. They'll get an offer from the state. And you can either accept the offer or not accept the offer. If you choose not to accept the offer, then what will end up happening is you will have a jury trial. Witnesses will be called by the state. Based upon this, I'm assuming they're going to call the police to come in and say why they ended up arresting you, what they saw, what they heard, things of that nature. Of course, there'll be rules of evidence, hearsay, and that type of thing. They'll call in the chemist. The chemist will say, these are the drugs that were brought to me by the police. I weighed them. This is how much they weigh. I tested them. This is what it came back as. That's it. Normally with drug cases, at least when I was practicing law, the only way to sort of help your client, or I don't want to say help, but the only question really is it a good stop? Is the search warrant good? If the search warrant is good, or if the stop is good, you're pretty much stuck like Chuck a little bit, because it is the chemist is going to come in and say, this is how much it weighed. The chemist is going to say, yep, this is all I did. And usually the chemists don't have a dog in the fight. They don't know you. Their job is just to get drugs from the police or whatever agency, test it to see what it is, and put in their report, I tested these drugs. This is how much it is. And what I can tell you with chemists, they're not going to measure the full 200. If you're charged with possession with intent 4 to 200 grams, they're not going to test 200 grams. They're just going to test enough to get where it needs to be. If they think it's a lot, they'll test probably about 20 grams, because then you're between the 4 to 200 grams. If it's 1 to 4 grams, they're probably going to test till they get to about 2 grams and a little bit more. And then that's it. And usually there's really nothing to cross the chemist about, unless it's a bad chemist, has some bad things in their past as far as their inability to test and identify drugs. So usually the chemist part is out the window because they don't have a dog in this fight. Then the state will call the police officers in. Your attorney will have a chance to question them. So here are your choices today. You have a plea deadline date. Your plea deadline date was extended. You can either accept this plea, or either you can go to a bench trial or a jury trial. Those are your 3 choices. So 1, do you want to accept the plea? Yes or no? I don't know what the plea is, but do you want to accept it? And if the answer is no, what's going to end up happening, the court will not accept any plea bargaining agreements in this case without good cause. Otherwise, you're going to have the plea open to the court. So first question, have you received an offer from the state?
Yes, ma'am.
Do you want to accept it? Yes or no? State, do you want to give him till Monday?
Judge, I'll leave it open till Monday. I left it out open till today's, and after rejected it, but I will leave open this.
All right. So here's the thing. Monday is going to be your last day. And when I say,
take the deal.
well, no, here's the thing. I don't want you to be rushed. Are you sure this is what you want to do?
We'll get out in more years if I take it to trial.
No, here's the thing.
Yeah.
What I will do is, they're saying they're going to keep it open till Monday.
Yeah.
We're going to have you come back on Monday. Your defense attorney is going to be here at 9 a.m. on Monday.
I'll visit him this weekend.
All right. And then we will bring you over. And if you want to accept the offer, then I'll hear it and I'll go from there. And what I can tell you is, when the state presents their evidence to me, even though you're entering a plea of it, I still have to review it and see if the state has proved their case beyond a reasonable doubt. So I'm another person who looks at it, okay?
Yes, ma'am.
All right, so we're going to bring you back on Monday, and after that, there will be no further extensions.
Appreciate you, ma'am.
All right, thank you.
Thank
Have a
you.
good one.
You
You
too.
too.
Go that way.
Felipe Reyes, where are you all? Hello, how's it going?
Yeah.
Hello,
How you doing today?
I'm doing great. So when were you hired on this case?
Friday, yeah.
So that's Friday the 9th?
I believe so, Judge.
May 9th?
I believe that's what, oh, sorry, not the 9th. The 16th, Judge.
All right, so here's the thing. I don't allow people to do this thing where they wait till the last minute to hire an attorney so they can get a continuance and their attorney is entitled to 10 days. Do you understand? So I'm giving him exactly 10 days. So you're coming back on the 27th and you're going to jury trial. My understanding, State, is this offer still on the table or no? All right, so today is your plea deadline date. So either you all reach an agreement or you have not reached an agreement. If you're not reaching an agreement today, then the court will not consider any plea bargain agreements without good cause. Otherwise, you're going to have to plead open to the court. So you're coming back for jury trial on May 27th.
Thank you, Judge.
Anything else?
Nothing from the defense, Your Honor.
All right, Ms. Ferguson, they're on the docket for jury trial May 27th, and they're number one.
Yes, ma'am.
Thank you.
Thank you, Judge.
Court is calling 2025 CR 000700. Is this the only case?
000701 as well, Your Honor.
All right. And 2025 000701. Could I have parties announced?
Andrew Harris Edelman from the state.
And this is Pauline Portillo along with Ms. Peyton Howe for Mr. Felipe Cerna-Reyes.
All right. You all are scheduled for jury trial today. You filed a motion for continuance?
I did, Your Honor.
All right. And why?
We have several reasons. We do have a motion to inspect and examine evidence, which if granted, I think will require us some time to inspect and examine that physical evidence.
Why wasn't that done before today?
Because, Your Honor, through preparation with my client, which was very limited because of the time frame which we represented him, this was information I had to develop over the course of jail visits, which I couldn't get within 24 hours. And so through prepping with my client, we learned of some evidence that might be, and I would expect strongly, would be material and mitigating to the elements in the case. And so that's the reason why it wasn't filed earlier on in our representation of him, but it was filed before the jury trial date of
27.
the 27th, yes.
All right. Anything else with regards to your motion?
I'm sorry, it was filed May 23rd, 2025, and I'll address that motion in a second. But the other issue is, Judge, we had requested missing discovery from the state, and since that request, we've gotten in about 12 videos that are pretty large, and even the state said it's a pretty big file that it took.
What missing discovery?
At this point, it's all been produced, but they are all recordings from SAPD personnel who are at the scene.
Okay.
And they're pretty large videos, Your Honor. And one of them, I think, includes the unmuted portion of the defendant's statements. And I also believe that that's going to have material and mitigating evidence for his defense. So it's really, really crucial for us to be able to review all.
All right. So review the video now.
Judge, these videos are an hour and a half.
Review the videos now.
Will do, Your Honor. And then the other issue with the motion for continuance is the other issue with the motion for continuance, Judge, is that to prepare an adequate defense for him and to avoid issues of this case being appealed for ineffective assistance of counsel.
People love to throw around ineffective assistance of counsel. This case has previously been set He had another attorney. It was set for jury trial, and your firm decided that you were going to represent him and get on a case knowing that it was set for trial. So if you all want to throw your swords on ineffective assistance of counsel and file that with the appellate court, that's completely up to you. Next
I understand
point.
that, Your Honor. The issue is that it is very apparent to me that because there was so much missing discovery that was never requested, that there was not adequate prep work by the prior attorney, and that's why, unfortunately, and I don't want it to be held against him, it's taking us so long to put everything together and figure out the missing pieces.
Oh, no, name the parties who you're saying didn't complete adequate discovery.
Name the parties that
Oh, yeah, who are you talking about?
the state.
Okay.
So the issue, Judge, is that I don't think that this should be held against him. He's facing substantial jail time. It's an enhanced first degree possession with intent to deliver. And so those cases, they require a lot of links, a lot of connecting the dots. And so my argument for the continuance would be that we definitely need some more time. Just
All right, the video is like an hour. What did you say, an hour and what?
So the 12 videos, each one starting at least at about an hour and a half long.
All right, so y'all need to watch the videos today. He's here, you're here, watch the videos. Next point.
We'll do, Your Honor. But the other point is that this is a case that has a lot to it. And so it's not just a regular, like a DWI third or another felony that you could get ready for very quickly. And so given the nature of this case and the prep work for it, that is a little bit above and beyond another felony. And this court, that's also the reason for the continuance.
All right, but you all knew that this was set for jury trial. And so you all chose to do it. You've been given your 10 days. So what's your other grounds for a motion for continuance?
I don't have any other grounds for my motion, Your Honor.
All right, so you all need to look at the whatever video she says he needs to see. If you will load it up so she can watch the video with her client.
And Judge, I tried to do that when I was here about a week and a half ago, and the state never was able to give me the video because they were too busy. And so
Well, do you see anyone else here now? Load up the video so she can watch it with her client.
Don't you have access to it now?
we requested, but it doesn't come over right away.
So you
It
don't
takes-
have it?
So the other issue, Judge, is we have a motion to inspect and examine physical evidence. The state tells me that they're not opposed to it.
Well, you all should have done that before your 10 days. You had plenty of time to inspect evidence. So,
Okay, is the court going to rule on it?
oh yeah, you can expect whatever evidence you want to inspect, but I am not granting a motion for continuance because you all have not inspected evidence that was always available.
Would you like a copy?
They've given me copies of your motion. So state she wants to inspect evidence. Is there any other motion?
Judge, it's just there's two motions for each cause number.
Okay.
So I just wanted to see if we could get your signature on both cause numbers.
Okay. And other than that, is there any other motion?
Yes, we have a motion to require disclosure of all informers relied upon and for production of said informers.
All right. So what are you basing that? And you're speaking of a confidential informant?
I believe it is, Your Honor.
All right. So there are certain grounds legally where you're allowed to that information. So what are you basing that request
So,
on?
Judge, there's a reference to an anonymous tip by the detective in this report. And so I don't know, I think we need to call him in to at least get some testimony about what the anonymous tip was. And generally speaking, like, what's the nature of it? What did it reveal? And if it's somebody that this person has worked with in the past, because that's all I have is that it's an anonymous tip. There's no other
Stay.
information included there.
I can call Ramirez, see if we can get him here.
Okay.
And then we just have other pretrial motions that I expect we could argue.
Did you all confer with the state on your pretrial motions?
I haven't. Does the court want to take them up at this time?
Well, I mean, don't you want to confer with the state to see if they're in agreement with your motions? Or not the state agrees with your motion, then maybe you wouldn't need to have a hearing on it.
Yes.